Delivery of order item 1.
Mr. Monto,
My lord.
anything more to add? Nothing?
Nothing.
You can go. We'll slowly dictate. No problem. If you have any other cases, you can go and attend. No
My lord.
problem. But two judgments, child court,
My lord.
I may have to go against.
No, that honorably acquittal, but I am on that because and I have
There is a
denied the
judgment
allegation.
which says, I'll quote that. It's 2013 1 SSC 598.
2001
1 SSC 598.
SCC
598.
598.
S. Sammu Theorem, wherein it says that if there is no provision in the rules for reinstatement after you have been subsequently acquitted, para 26, that you cannot, and very emphatically said so.
My lord. No.
And what I have found is that, yes, it's true. But the departmental proceeding, rape is not there. Cheating is not there.
My lord.
It's a question of you being there with her.
My lord.
A person not authorized. You are with her. And
No.
The appellate order, in a way, substantiates that. It only says it was consensual. That's why 376 will not come.
That appeal order. Appeal order. No, I understand. Your lordship, my lord, do more research than me. I understand. I know. So that's why I'm satisfied. But my lord, only thing is that my lord, that same setup. At that point of time, if he came to the High Court, my lord, definitely there is a stay order because there are parallel proceedings.
Maybe his pony is going on. Maybe in the appellate stage it will be.
My lord. Yes. Even my lord, the client, my lord, after getting acquittal, he, my lord, came to me, said, no, sir, do something for me. My lord, that
He should have come at that point
yes,
of time.
that point of time it is early.
Then
Anyway, my
we
lord.
could have concentrated on the proceedings in the appeal. But now that you have allowed it to become final,
My lord.
8 years, one judgment is also there, where this delay.
Delay. But
I'll not
delay,
go
I have
much
no answer. And point delay,
I'll not go much into that. I'll only say,
my lord.
rest up to you.
My lord. Deeply open. No, he'll be there, my lord. I have another item, my lord.
Heard Mr. P.J. Monto, Learned Counsel, for the petition. Assisted by
A. Burua.
Mr. A. Burua, Learned Counsel, appearing for the petitioner. Also, who appeared on the last date? Mr. D. Bora.
D. Bora appeared.
Also heard Mr. D. Bora, Learned Comment at Phuket, appearing for all the respondents. Also, the petitioner, by way of instituting the present proceedings, has presented a challenge to an order dated 1/8/2005 issued by the Superintendent of Police, Tulaka, Disciplinary Authority, imposing the penalty of removal from service upon the petitioner. Also, the petitioner has also assailed an order dated 25/4/2006 issued by the Deputy Inspector General of Police, Central Jail Range, Koidia, Assam, Koidia, this appellate authority, whereby the appeal as preferred by the petitioner in the matter came to be rejected. Also, the facts as requisite for consideration of the issues arising in the present proceeding is noticed hereunder. The petitioner was initially appointed as an armed branch constable under Golaghat DF in the year 1996. Also, while working in the said capacity, the petitioner, on being involved in a criminal case being Purupatar PS case number 30/2003 under section 493/376 (2) IPC, was placed under suspension while issuance of an order dated 15/8/2003. Also, they said order of suspension was followed by a show cause notice dated 23/9/2003 issued under Section 7 of the Police Act, read with Rule 66 of the Assam Police Manual Part 3 and Article 311 of the Constitution of India. Also, the petitioner was charged with misconduct, indiscipline, and negligence of duty, basing on the allegation as was leveled against him therein. Also, the petitioner thereafter on 21 petitioner on receipt of the said show cause notice on 21/10/2003 proceeded to submit his written statement in the matter, and therein, while denying the allegation as leveled against him, had, by referring to the Sessions case now pending against him, had prayed for keeping the proceedings in the departmental inquiry in abeyance till conclusion of the criminal proceedings. Also, the said representation not being found to be satisfactory, the Disciplinary Authority proceeded to direct for holding of an inquiry against the petitioner in the matter. Also, accordingly, with the participation of the petitioner, inquiry was duly conducted against him, duly conducted against the allegation of the charge as leveled against the petitioner, while the show cause notice dated 23/9/2003. Also, on conclusion of the said inquiry, the inquiry officer, while his report dated 2/7/2004 proceeded to hold the charge as leveled against the petitioner to be proved. Allegation as leveled against the petitioner to be proved. Also, the copy proposal. Thereafter, the disciplinary authority, while his communication dated 17/7/2004 proceeded to issue, proceeded to direct the petitioner hearing to submit his representation in the matter and to show cause as to why he should not be removed from his services. Also, thereafter, the thereafter petitioner submitted his show cause, his representation against the communication dated 17/7/2004 on 1/8. Submitted his representation against the show cause notice dated 17/7/2004. So, the disciplinary authority thereafter, on perusal of the reply as submitted by the petitioner in the matter in pursuance to the communication with 17/7/2004, as well as on examining the other materials available on the court, proceeded while order dated 1/8/2005 to draw a conclusion that the petitioner on account of the charges of the allegation as leveled against him being true, was not fit to be retained in the service of the police department, and accordingly proceeded to impose a penalty of removal from service on the petitioner. Also, the period of his suspension from 14/8/2003 to 14/11/2003 was, however, regularized as on duty. The petitioner being aggrieved proceeded to prefer an appeal in the matter while his appeal dated 6/10/2005, and therein by advancing his contentions prayed before the appellate authority to interfere with the impugned order dated 1/8/05 passed by the disciplinary authority. So, sir, the appellate authority on a due consideration of the contentions as raised in the matter in the appeal in his appeal by the petitioner, and also on perusal of the materials coming on record in the inquiry, was pleased while proceeded while order dated 25/4/2006 to reject the said appeal. So the said rejection had occasion on 2006, and the order of penalty with regard the penalty insofar as the penalty was imposed upon the petitioner on 1/8/2005. Also, as projected in the petition, the criminal case as instituted against the petitioner upon conclusion of trial led to his conviction, while an order dated 8/2/2006. Also, the petitioner thereafter had assailed the said order of conviction by his order of conviction by the trial court before this court by way of filing a criminal appeal being criminal A CRL A 33 of 2006. Also, the said criminal appeal was given final consideration by this court while order dated 31/2013, and this court on examination of the matter was pleased to interfere with the impugned judgment of conviction dated 8/2/2006 passed by the Session Judge Gulaghat in session case number 162/2003, learned session judge. Full stop. The petitioner on a petition on his acquittal by this court in the criminal case instituted against him, the petitioner proceeded to submit a representation dated 26/2/2013 before the Superintendent of Police Gulaghat, praying for his reinstatement in service basing on his acquittal in the connected criminal case by criminal case, also the same not having been duly considered, the present proceedings were initiated for this court. Also, Mr. T.J. Montauk, learned counsel for the petitioner, after having taken this court through the show cause notice and also the inquiry report, has submitted that the inquiry report and the order dated 31/2013 passed by this court in criminal appeal number 33 of 2006 has contended that the petitioner, having been honorably acquitted by this court from the charges as leveled against him in the criminal proceedings, and also the criminal proceedings and the departmental proceeding as instituted against the petitioner being based on the same set of facts and the witnesses also being one and the same set of allegations, and the evidence coming on record in both the proceedings and the witnesses deposing therein and the witnesses deposing in both the proceedings being almost the same, the acquittal of the petitioner in the criminal proceedings being after a due consideration of the evidences coming on record, by this court, the order of removal as imposed upon the petitioner while the order dated 1/8/2005 cannot be sustained and requires to be interfered with further direction to the respondent authorities for his reinstatement in service with all consequential benefits. Mr. Mortiz Montauk, learned counsel, has by taking this court through the, by placing, by taking this court through the inquiry report has contended, has submitted that there is no clear finding recorded in the inquiry report by the inquiry officer with regard to the allegation public charge as leveled against the petitioner, while the show cause notice dated 23/9/2003, and by drawing a sudden conclusion that the allegation brought against the appellant to be proved, the inquiry report was closed. Also, it is submitted that the manner in which the inquiry proceedings were so conducted, and also the manner in which the charges leveled against the petitioner was held to be proved was by the inquiry officer, the same reflects the clear non-application of mind, and also that there was a premeditation to hold the petitioner guilty of the charges so leveled against him in the departmental proceedings instituted while the show cause notice dated 23/9/2003. Also, Mr. Monta has further submitted that in view of the has submitted that both in the written statement as preferred by the petitioner against the show cause notice dated 29/3/2003, 23/9/2003, as well as in the representation as preferred by the petitioner against the inquiry report, the petitioner had categorically contended that the allegation as leveled against him of cohabitation with the complainant in the matter was categorically denied. However, the respondent authorities, while considering the case of the petition, had ignored such categorical assertions made by the petitioner in the matter. Also, in support of the submissions as made by him in the matter, Mr. T.J. Mohantal and Senior Counsel has relied upon the decisions of the Honorable Supreme Court of India in the case of Ramlal versus State of Rajasthan, was reported in 2024, 1 SSC 175, and GM Tank versus State of Gujarat and others, reported in 2006, bracketed 5 SSC 446. Mr. D. Bora Lanet, per contra, Mr. D. Bora Lanet, common advocate appearing for the respondents, has at the outset submitted that the disciplinary proceedings against the petitioner had come to an end with the imposition of the order of penalty dated 1/8 with the imposition of the penalty of removal upon him, while the order dated 1/8/2005. So thereafter, the appeal as preferred by the petitioner was also rejected, while the order dated 25/4/2006. Also, Mr. Bora, above 6, but the petitioner had not assailed the said orders before this court at any point of time before 18/7/2013, when the present writ petition was so filed before this court. Also, it is contended that the orders dated 1/8/2005, as well as the appellate orders dated 25/4/2006, has in the meantime attained finality, and the petitioner cannot now be permitted to challenge the same, basing on the acquittal basing on his acquittal in the criminal case as pending against him, while the order dated 31/2013 passed by this court in criminal appeal number 33/2006. Mr. Bora has further submitted that the petitioner has not brought on record any material to demonstrate that the disciplinary proceeding was so held without giving him a due opportunity to defend the, defend his, to defend himself in the matter. So it is contended by Mr. Bora that the petitioner was afforded due opportunity to cross-examine the witnesses who had deposed in the inquiry. However, the petitioner, for reasons best known, had refused to examine the said witnesses. So accordingly, it is the contention of Mr. Bora that the standard of every evaluation of the standard of evaluation in a departmental proceeding being that of preponderance of probability, comma, the inquiry officer basing on the materials coming on record and given the allegation that was so leveled against the petitioner, comma, had arrived at a conclusion of the charge so leveled against the petitioner to be proved. The disciplinary authority on a due examination of the conclusions reached by the inquiry officer in the matter, also having noticed the material so coming on record in the inquiry, had proceeded to impose upon the petitioner the penalty of removal from service by the order dated 1/8/2005, and the same was also upheld by the appellate authority by the order dated 25/4/2006. Also, in view of the above, in the above premises, Mr. Bora submits that this court, that no interference with the penalty as imposed upon the petitioner is called for, and that too only on the grounds of his subsequent acquittal in the criminal case. Also, I've heard the learned counsel for the parties and also perused the materials available on record. The petitioner was white show cause notice dated 23/9/2003 required to was alleged to have visited the house of one Mamuni Gogoi frequently, leaving his place of posting without any leave or permission from the competent authority since 1.5 years last. Also, it was further alleged that being a married man, the petitioner had pretended to be unmarried and cohabited with Ms. Srimati Mamuni Gogoi with inducement of marriage, and as a result, she became pregnant and gave birth to a male child at Horupathar 30-bedded hospital on 10/8/2003. Also, basing on the said allegation, it was also recorded in the show cause notice that being a member of a disciplinary force, the petitioner had acted in a matter which was not only disgraceful for him, but also for the entire police force, which had rendered himself unfit to be retained in service. Also, basing on the allegation so level, comma, a charge of misconduct, comma, indiscipline and negligence of duty came to be drawn against the petition. Also, the petitioner thereafter, while his show cause reply dated 21/10/2003 had denied the allegation of having cohabited with Ms. Mamuni Gogoi with inducement of marriage and by posing as a bachelor. Also, the petitioner had also, in his written statement, raised objection with regard to continuance of the departmental proceedings. But I will give you the petitioner had also, in his written statement, drawn the attention of the authorities to the fact that the session case now pending against him involves similar issues as that, similar allegations as that now leveled against him in the departmental proceedings. Also, in the inquiry that followed the show cause notice dated 23/9/2003, the petitioner had duly participated in therein, and it is seen that the petitioner had refused to cross-examine the witnesses who had deposed in the said inquiry. So, and the inquiry officer in his inquiry report had recorded a finding to the effect that the petitioner was given due opportunity to cross-examine all the witnesses deposing in the inquiry, but he had refused to cross-examine any of the witnesses so deposing in the matter. Also, the said position has not been disputed by the petitioner in the writ proceedings. Accordingly, also, the inquiry officer, basing on the materials coming on record, proceeded to hold that the allegation leveled against the petitioner in the show cause notice date was proved. Also, at this stage, it is to be noted that the petitioner in the writ petition has not brought on record, has not disputed the dispute, has not raised an objection with regard to he having been deprived of a due opportunity to defend his case in the inquiry so held. Also, thereafter, after having provided the petitioner with the inquiry report, and a reply thereon received, the disciplinary authority, while order dated 1/8/2005, proceeded to impose upon the petition the penalty of removal from service. Also, the appellant, the petitioner being aggrieved, had submitted an appeal in the matter on 6/10/2005. In the said appeal, the petitioner had raised a justification with regard to he not cross-examining the witnesses deposing in the inquiry, with the contention that in view of the pendency of a criminal case against him, he had refused such to cross-examine the witnesses so as to not expose his defense in the matter. Also, the said appeal as preferred by the petitioner was rejected by the appellate authority by a reasoned order dated 25/4/2006. Also, at the outset, this court, the evidences as coming on record in the inquiry admitted that the witnesses deposing in the inquiry having admittedly not been cross-examined by the petitioner, their statements having not been disputed, the inquiry officer was not in error in taking into consideration such undisputed statements coming on record in the inquiry. The contention as advanced by the petitioner in the appeal to the effect that he had refused to cross-examine the witnesses only on the ground that if he had so done, his defense would have been exposed and it would have caused prejudice to him in the criminal proceeding. So they said contention of the petitioner is being noticed only to be rejected in as much as the defense of the petitioner, if any, had already been disclosed when he had preferred his written statement in the against the show cause notice in question. First off, accordingly, the petitioner not having challenged the continuation of the departmental proceedings against him, comma, at a subsequent stage, after having submitted to the departmental proceedings, comma, he could not have taken up any plea contrary to the above position. Full stop. The allegation as leveled against the petitioner being relevant in the matter is extracted here in below. Page 14. Full stop. A close examination of the said allegation would reveal that what was so alleged is that the petitioner, by leaving his duty, while on duty, had left his post and had visited the house of Mamuni Gogoi and had cohabited with her for around a year and a half. Full stop. And also that she had induced so and so to have a relationship with him, induced her with the promise of marriage to have a relationship with him, resultantly making the said person pregnant. Also, although Mr. Mohanto, T.J. Mohanto, learned counsel for the petition, senior counsel for the petitioner has strenuously argued that both the allegation as available in the departmental proceeding as well as the criminal proceeding are one and the same. This court is unable to accept the said contention in as much as what was alleged against the petitioner in the criminal proceeding was an allegation pertaining to section 376 and 417 of the IPC. 417 IPC. Post up. The appellate court, that is, this court, while order dated 31/2013 in criminal appeal number 33 of 2016, had held in favor of the petitioner with regard to Article 3, section with regard to the allegations leveled against him under section 376(1) on the ground that the relationship between the petitioner and the lady were consensual. So, in this connection, the relevant observation of the learned court of this court in the said order dated 31/2013 is extracted here in below. Para 8 to 2. Eight, 9, 10, 10 even. Also, the said findings as recorded by this court in the said appellate order. In the said order dated 31/2013, while negating the allegation leveled against the petitioner with regard to the offense under section offense committed by him, alleged to have committed by him under section 376 and 471 IPC, also brings to the forefront that the petitioner had been in a relationship with the lady as whose name is mentioned in the show cause notice dated 23/9/2003. Full stop. In the show cause in the departmental proceedings as initiated against the petitioner, there being no allegation of the petitioner having committed an offense akin to 376(1) and or 417, and it only being to the extent of the petitioner having maintained a illegal relationship with a person, with the lady mentioned in the so and so while he was posted for duty, the observations as made by this court in the order dated 31/2013 proceeds to establish the said allegation. Full stop. In that view of the matter, this court holds that the allegation as leveled against the petitioner cannot be contended to have been so leveled without there being any material to substantiate the same. Also, so at this stage, it is relevant to note that the departmental proceedings as initiated against the petitioner had concluded in the year 2005, and the appellate authority had also passed its order in the year 2006. Thereafter, till 18/7/2013, the petitioner had not assailed the said proceedings. Till 17/7/2013, the petitioner had not assailed the said orders, which had since, which accordingly had attained its finality. It is only on 18/7/2013 when the present proceedings were instituted before this court, assailing the said orders. Full stop. The present petition has been solely filed on the basis of the acquittal as granted to the petition by this court, while the order dated while the order dated so and so 31/10/2000, while the order dated 31/2013. Also, it is in this connection this court would like to refer to the decision of the Honorable Supreme Court of India in the case of Deputy Inspector General of Police and another versus S. Samuthiram, SAMUTHIRAM, reported in 2013 1 SSC 598, wherein the Supreme Court under similar in a case involving similar circumstances had concluded that mere acquittal of an employee by a criminal court has no impact on the disciplinary proceedings initiated by the department. Full stop. It further held that in absence of any provision in the service rules for reinstatement, if an employee is honorably acquitted by a criminal court, no right is conferred on the employee to claim any benefit, including reinstatement. Reason is that the standard of proof required for holding a person guilty by a criminal court and the inquiry conducted by a way of a disciplinary proceeding is entirely different. Full stop. The relevant paragraphs of the said judgment being applicable to the present proceedings is quoted here in below, para 26 or para 27. Also, applying the ratio as available in the said judgment in the case of so and so, S. Samuthiram Supra, to the facts of the present case, it is seen that the provisions under which the petitioner was proceeded against in the departmental proceedings, that is the Police Act, as well as the provisions of the rules under the Assam Police Manual Part 3, do not provide for a reinstatement of an employee who was imposed with a penalty of dismissal on removal, compulsory retirement, and subsequently acquitted in a criminal case. Also, it is to be noted that the penalty as imposed upon the petitioner, while the order dated 1/8/2005 was not on the basis of the conviction of the petitioner in the criminal proceeding, and it was on the basis of an independent proceeding initiated against the petitioner with the issuance of the show cause notice dated 23/9/2003. Also, in the view of the matter and also applying the decision, applying the directions as applying the ratio of the decision in Samuthiram, so and so, Supra, comma, the petitioner in the view of the fact that the service rules governing him having not made any provision for his reinstatement on his subsequent acquittal in the criminal proceedings, comma, this court is of the view this court is of the considered view that the prayer of the petitioner for an interference with the orders of penalty as well as the appellate order, as well as the order passed by the appellate authority does not merit acceptance. So, in view of the conclusions as reached herein above, the decisions as relied upon in the matter by Mr. P.J. Mountain is not being alluded to. Also, the petitioner having not promptly presented a challenge to the order of dismissal, order of removal as imposed upon him by penalty of removal as imposed upon him by the order dated 1/8/2005, comma, as well as the decision in the case of Samuthiram of the Honorable Supreme Court in the case of Samuthiram, comma, this court proceeds to hold that there exists no ground at this belated stage to interfere with the orders impugned in the writ petition. Also, accordingly, the writ petition is held to be devoid of any merit and the same stands dismissed. However, there would be no order as to cause. Upay. Slight, something may go in, something may come out, but this would be the final conclusion.
Item 2 and 3.
Yeah, by the better. Roll up here. Not possible. After giving one, they can't. I'll fix a date. Don't worry. By the way, Puno try pana bola de. Puno try. Father heard. Puno try. Yes, Mr.
Hello,
Yeah.
Motion item 4.
Sorry, you was a motion item because you were not here, though we took up
My
that.
lord, I have filed an additional affidavit, my lord, that may
It's
be
here
tagged
on
with it.
record.
Yes, ma'am.
Yes.
No, my lord, today I have filed, it is not on record. That may brought in,
You can give me a copy.
my lord. Copy of the affidavit.
Ah.
Yes. ma'am.
When Mr. Sheikh says something, why should we
My lord.
have even a small apprehension? You had filed an affidavit on 22/4.
My lord, this is second, my lord,
Okay.
additional affidavit. Second additional affidavit.
Yes, Mr. Sheikh, what is here?
My lord, my submission before your lordship,
Hmm,
your lordship will take my first affidavit.
just a minute.
First affidavit to be filed down. 22/4. First affidavit, my lord, 22/4/2024. My lord, your lordship, remember that case, I am the president of a school management and development committee. I was arrested by police.
Police, then you
After what happened, my
came
lord,
out on bail?
I was replaced.
Hmm?
I was replaced by
That's it, you came out on bail,
someone.
you came out on bail, but
Hello.
still they have not
Hello.
put you back.
Hello.
My
Yes.
question to you was,
My
where
lord,
is your right to come back?
no, now your lordship. would be
Now you
pleased to
show me.
see My first affidavit, my lord,
Hmm,
page 38.
hmm,
So this is a notification.
hmm,
Here, my lord, last but one paragraph,
hmm.
the other terms and condition, including grounds of dissolution of SNCs,
Hmm.
shall remain the same as mentioned in the government notification.
Hmm.
Notification number 6th of August 2014. And another notification 29th of December 2000.
Yes, Mr.
Now your lordship would be pleased to take my second affidavit, what I have placed before your lordship.
Page 44.
Yes, my lord. Now, your lordship, I have annexed those those
Mm.
notification, my lord.
Mm.
Now, your lordship would be pleased to go to page 47, my lord.
Mm.
Point 1.4.
Mm.
Dissolution of School Management and Development Committee. Your lordship.
Now tell me one thing before I go
My
into
lord,
this.
your lordship,
I'll go into this.
my lord.
President removal will lead to a dissolution of the SMDC or
My lord,
SMDC
here,
will
here your lordship would be pleased to, under certain notification, I was made the president of a SMDC
you were made a president and thereafter the SMDC is
constituted.
You come in as a president.
My lord, now,
So
now
today,
what happened?
Mr.
Now what happened? The
Just a doc-
authority want to say
Hmm.
that there is a provision
Hmm.
for dissolution of Management and Development Committee.
Fine.
There is
Whether
some
you
ground.
are- You are the manager, whether now that
My
you
lord,
were removed,
my
you
lord,
were removed or you were not allowed to
my
join
lord, my
back.
lord. Now your
Now
lordship.
that SMDC is gone.
My lord, I'll try to answer your lordships.
Ah.
Let me see first the documents I have annexed. Now your lordship will turn to another notification.
So
Page
this is
50.
page 47 is dissolution of SMDC.
Dissolution of School Management and Development Committee.
Okay, then
But earlier notification said that regarding dissolution, these are the notification.
Hmm.
Now your lordship will turn to page 50.
Hmm.
Dissolution and my lord, 1.4 again. Dissolution of School Management and Development Committee. The SMTC shall be also dissolved if it fails to ensure unable clean the toilets and school so and so.
it is added in that.
My lord. Now your lordship, now I will try to answer your lordship's query that I was arrested.
Hmm.
I was arrested and when I got bail, my lord, on that particular day, the impugn order was passed. But giving the charge of
To some.
president to some officer. Now my humble submission before your lordship. Where is the provision? Where is the provision that a school management committee president is arrested by police on a criminal charge, and he was granted bail, and if he is arrested, my lord, your lordship will remember this discipline and appeal rule. If I am in custody for 48 hours, a government servant, he can be suspended. Now what happened in this case, my lord? This provision, I am not a government servant. 1964 rule does not apply to me. Now, what rule will apply? Now what happened, my lord? I have been arrested. It's not that I was convicted or charge has been framed. Just I was arrested on some allegation. That allegation is not proved against me.
Hmm.
And immediately I have been
Hmm.
replaced
Hmm.
without even suspending me.
Can you be suspended?
My lord,
You can't be suspended.
I cannot be suspended under 64.
You
Rule
cannot be
64, I am
suspended
not a government servant.
because there is no
My lord.
employee-employer relationship with you.
No relation. Now what happened, my lord? Supposing somebody may file a case. And when case is filed, immediately I was arrested. Now my question before your lordship,
Understand?
without suspending me, I cannot be suspended.
You cannot be.
Whether I cannot be replaced without any law.
No, Mr.
What is the problem?
Sorry,
My lord.
Mr. Sheikh may
My
take it in another manner.
My
But
lord,
this
yes.
is a genuine query from this court.
My lord,
Genuine query.
my lord,
Now, I want to understand
my lord,
what is your right? Not in this case, but I'm getting a lot of cases.
my lord.
What is your right in these cases?
My lord, my
You are
humble
not
submission-
covered by 311.
my,
You are not covered by.
no,
60.
not covered.
There is no.
There is no
employer-
coverage.
There is no.
There is no
employer-
coverage.
No, there is no employer-employee
No,
relationship.
no relation,
You
nothing.
are a man. You
Nothing.
have been brought.
I have
It's
been-
not that you.
I have been
only
replaced.
You have the qualification. There are hundreds
My lord,
who have that qualification.
yes, my lord.
Anybody can be brought in, but in that
My-
process.
my lord.
Now, in that
No,
view of
my
the
lord,
matter,
eh,
what
my-
is your right?
My very submission before your lordship,
I
to
wonder.
be considered by your lordship, that when I was selected as president, some authority vested with me.
Hmm.
What your lordship said, what is your right?
To continue in this circumstance.
State given me something.
Hmm,
Something is vested with me.
hmm.
That vested right, I will say that vested power, vested right has been taken away. Can it be taken away without
That's-
showing,
that's
without
why-
showing any reason?
That is what I want.
My
from
lord,
you.
my lord.
That is what I
That
want.
is the thing. What notification they refer to, my lord?
You, this.
My humble
notification,
submission
Mr.
before your lordship,
Mr.
not a
Sharif,
single notification
Mr.
provided.
Sharif,
My-
This, forget it.
My-
These notifications, forget it. Show
Everything.
me some law somewhere
My lord, yes,
that in this circumstances, I've been trying and not got it.
no,
Show me that under these circumstances, the government will have to give you a notice.
my lord. My lord,
Just show me, sir.
no, my lord. Before showing, there is nothing, my lord. There is nothing that they have to show cause me. They have to suspend me. They will replace me. I have a vested right without any reason. No reason has been shown.
Mr.
I have been. replaced.
Sharif, what's the problem I am facing? I'm
My
telling
lord,
you.
my lord.
Now, in your case, the allegation may be personal. There is an allegation that you had killed your wife.
Mhm.
Suspicion.
Mhm.
But tomorrow, say in that school, there is an allegation of POSCO against a person. I'm
Mhm.
telling you, POSCO Act.
Yes, my lord.
There is an allegation of POSCO Act against a president. I'm telling you. Or there is an allegation that he has misappropriated a large sum of money. Now, in this view of the matter,
My lord.
if we in your case today hold that because a power was vested on me, without a law, you cannot take it back. It would mean that in those cases also, because that will apply across all a decision until and unless it's annulled by the division bench. In that view of the matter, whether it will be in public interest to allow those persons to be in the helm of affairs in the schools.
My lord, my humble submission before your lordship is this. Supposing, my lord, XYZ filed an allegation against me.
That is my
I'm a
problem.
dignified person.
That is,
My lord, your lordship will consider. When I was selected, because I have something. I have position in the society, and that is the thing.
Mr.
That is the
Mr.
thing.
Mr.
I have a position in the
Yes,
society.
accepted, but you're not getting
Where
my
from
point.
you get this right?
You're
to
not getting
defame
my
me?
point. You're not getting my point.
My lord,
A criminal case is a criminal case. Forget what is inside that.
my lord,
Criminal case, criminal case.
my lord.
Now, today in your criminal case, this case, 17 years, 18 years afterwards, your wife dying, maybe there may be some other angle to that. Maybe somebody may have tried to frame you. It's not a case within 7 years of marriage. It is after 17 years, and the circumstances also is that she was found without any ligature marks and all that is there. But that is a criminal case. So today I pass an order saying that if a man is arrested in a criminal case and he is released, he should be put back as the president or the vice president of a school managing committee. That will apply across the board to all criminal cases, wherever presidents have been involved.
Right.
Tomorrow, a person who is alleged of a POSCO Act
My lord.
with clear evidences, person with misappropriation of fund meant for the benefit of the children, this judgment will be applicable to them also.
My lord. Yes, your lordship is correct, but
That's my
take
apprehension.
my point also. In other side, my lord, Your lordship is to consider other side also.
I have to consider both.
Supposing, my lord, your lordship say that allegation against wife has been filed petition against you. Somebody may say that moral turpitude is there, that POCSO Act is there, that you have taken misappropriated the money. If this is the thing, then what? That's all right. But my humble submission before your lordship, I am an honest person. I have not committed any offense, but somebody rival to me
Accepted,
filed a case,
accepted, accepted.
and ultimately I was arrested
Behind
and
us.
I have been replaced.
So,
Will
Mr.
that be proper?
No. What I am telling you, I have to look into, I can't only look into Mr. Sharif's case when I'm laying down a law.
Hmm.
I'll have to look into all possibilities,
My lord,
possible possibilities.
my lord,
So in that view of the matter,
my lord.
and it not being a recruitment, in pursuance of a recruitment, and there being people who have the eligibility to be appointed, in that circumstances, Mr. Sharif is to address this court as to how this court will proceed.
My lord, my humble submission before your lordship, only point is this: I was duly selected.
Vested
should
with
not
the
be.
law.
I should not be removed like this. I
Then
should
tell
not be.
me, what,
I should not be
how you
replaced
should
by.
be, how you
I should not be replaced
No,
by
no,
that.
No, Mr.
Replaced
Sharif,
by that.
Mr.
And
Sharif,
even
I want an
after,
answer.
my lord,
I want an answer. Why I am
yes,
telling
my
you.
lord. Now, your lordship, another point is this. Whether after replacing also, some show cause has been issued to me. Your lordship pointed out that where is the provision of show cause? Where is the provision of removal?
That's why I'm saying.
My lord.
Where is
when-
the
when
requirement?
My lord, your lordship, when something has been done by the government, it is a scheme by which managing committee, development committee is constituted. They have given 3 notifications. In a single notification, it is provided if some president is in wrong, how he will be removed. You are doing something without any law. You are doing something. Yeah,
They'll
My
come
lord.
up with the plea
my lord.
that the power to appoint, General Clauses Act, power to appoint also has the power to remove and dismiss.
My lord, but power to appoint has power to dismiss. In this way, my lord, this free hand cannot be exercised.
This is my apprehension is on
This,
that point.
this free hand game, my lord, they cannot, because if they have done something,
I was expecting that today Mr. Sharif will give me some material
my lord,
to hit.
my lord,
Because I have to look to the other side also. Mr.
my lord.
That's the only apprehension. I have.
My lord, your lordship, without
Why
any
don't you, why
scheme,
don't you?
nothing, government,
Hmm.
my lord, government being the authority, without any scheme, my lord, without any whisper, how it will be dealt with. Supposing some president is involved in misappropriation of the
That's
money
what-
of the school,
That is what I
then
want.
what action will be taken against?
That is what I want.
There should be,
That is
there
what I
should be
want.
law. Without law, my lord, that cannot go like this. Today, my lord, I am the victim. Another person will
No,
be victim.
today, maybe, let's for argument take sake that it was a frivolous argument, frivolous complaint against you. But there is a criminal case.
My lord,
If we say that, okay, all persons who have been accused, they are an accused only.
yes,
Accused, you will continue
yes.
after your bail.
If,
After your bail.
Hmm.
Now, I cannot therein make a compartment that POSCO misappropriation, you will not, other criminal cases you will. That is the problem I am facing. I want an answer on that question, Mr.
so my lord, without guideline, my lord, I cannot be replaced. And nothing has been said in the order, my lord. Your lordship will looked into the order.
Nothing.
Nothing is there. Can it be, my lord? We are the citizen of the country. And we are in the hand of the government. Government in a sweet will place me somewhere. Today they are removing me, replacing me without any law. Why
Yes,
it is
Mr.
given and why it is taken away?
Yes,
My
Mr.
lord,
Sharma, what is your?
In this regard, I have received instruction here, my lord.
Hmm.
My lord, at first I want to point out notification 6 August 2020 to 14.
That Mr.
Term, my lord, here tenure and vacancy of the School Management and Development Committee.
Hmm.
Point number 2, the term of President and Vice President shall be for 5 years. In case of any vacancy arising out of death, termination or resignation or otherwise, the
Where are
authorities
you
shall
reading?
immediately
Where
nominate.
are you reading?
My lord, it is notification.
Hmm.
Notification of 6 August 2014, my lord.
Clause
Clause 2, my lord.
2. No, I have it. It's a, he has already brought it.
Hereafter, my lord, however, the nominating authority may terminate their nomination
No,
at
where
any
is that?
time
Where is
or
that? I'm not getting it. Clause number, just tell me the
clause
clause.
number 2, my lord.
2.
Yes, my lord.
2 of
Tenure and vacancy of School Management and
1.12.
Development Committee.
Okay.
One subclause 2.
Second notification.
Okay. This much only?
And my lord, as per our instruction also, same thing is written here, my lord.
Now tell me, was he removed? Or this will amount to a removal, that order? Page 29.
He has already removed, my lord.
Where is that order of removal?
My lord, order I am giving you. Impugn order, your lordship will get.
Page 29.
Page
There
20 page 29,
Therein your name is not there. No reference to you.
yes.
In our instruction on last paragraph, my lord.
Hmm.
It is observed that Sri Azizul Islam Haq, the petitioner whose name was nominated and approved as president of Navajyoti High School, Kathulipa, as
You have
well
not
as the
removed
function
him.
now.
Mr. Sir, you have not removed him. You said we will not allow him. Removal and allowing, not allowing, both two things. You tell him he is in a criminal case, Mr. Sharif, go home. We don't want you. Fine, no problem. But you keep him hanging. How can that be?
Now respondent number 8 is allowed to act as an president, my lord.
Hey.
Hello.
Now let me see what I can do.
Hello.
I'm keeping your this.
Hello.
Kumbara lokage. Kumbara ya woni.
My lord,
Mongalbara lokage.
my lord, may
Mongalbara.
I pray one thing, my lord? That what instruction has come, my lord?
Nothing.
Instruction has come.
Nothing. Only your 6/8/2014
Hello.
and that you have been removed because of the criminal case.
No, my lord, may I pray that may be placed by affidavit, my lord, before the lordship.
You will get it in my order.
My lord, answer, Lord.
Mongalbara.